You're good to go, Mr. Chavez.
Okay, good. So we are on the record. Our court reporter, are we on the record?
Yes, sir.
Wonderful. Okay. Good morning, folks. We are on the record. I'm Stephen Chavez, the city's land use hearing officer for the city of Albuquerque. Today's date is July 27th, 2020. This is an appeal. It looks like it's an administrative appeal, numbered AC 20-7. Now, the same admonitions regarding how this Zoom hearing works, I'll go through. To prevent possible background noise, I will ask everyone to essentially mute their audio or mute their cameras so that we don't get the backlag that can occur. So you want to turn off your cameras or mute them. Mr. Moya may also, who is our host for the hearing, may also mute your audio if somebody else is talking. So if you want to raise an objection or speak, you have to unmute your Zoom audio, not the audio on your computer, but on your Zoom program. And this hearing, of course, is being broadcast live on the city's YouTube channel, and it is being recorded by a certified court reporter. So beginning with Mr. Campbell, let's have entries of appearance. Mr. Campbell, you have to unmute your button.
Got you.
I'm
John Campbell, representing the appellants in this case, Ms. Levinson and Mr. Gill. Ms. Levinson is present at the meeting, as is one of our witnesses, Mr. Costello, who's also present. And everybody calls me Jack.
I'll refer to you as Mr. Campbell on the record, sir. But thank you. And then the assistant city attorney who is representing the city. Is anybody with the assistant city attorney's office here? Does not look like the city attorney's office is here. Okay. Sometimes they like to monitor these hearings. Regarding staff, Mr. Aranda, your entry of appearance?
Good morning. I am the Deputy Director of the Planning Department as well as Zoning Enforcement Officer.
Okay. Mr. Brito?
Mr. Chavez, Russell Brito with the Urban Design and Development Division of the City Planning Department.
Okay, and I understand Mr. Bazar, did I pronounce your name correctly, sir?
Biazar.
Biazar.
Yes, sir. Yes, sir.
Your full name for the record.
Shahab Biazar. I'm the city engineer with Planning Department.
Okay, and who else do we have?
We have Angelo Metzger, the Code Compliance Manager for the Planning Department.
Ah, Mr. Metzger, I didn't quite recognize you. Good to see you, sir.
Good to see you too, Mr. Chavez.
Okay, and who else? The gentleman with the sun setting is your client, Mr. Campbell?
He's a witness, Mr. Chavez.
Okay, I'm going to swear. I'm sorry.
I'm Sandy Levinson. I'm Jack's client, and Mike Gill is here with me as well.
Got it. Thank you, folks. Anybody who is testifying in this hearing, I would like to have you all swear in. Okay, so
Sure.
Please raise your right hands.
Raise your hand.
Looks like Ms. Levinson, Mr. Aranda, Mr. Metzger, Mr. Brito, and I'm sorry, the man with the sun setting. Your name again?
Costello, Mr. Costello.
Okay. Can you spell that for me, sir?
Koskelo. It is on the screen.
I see it now. Got it. Okay. So all of you folks, please raise your right hands. Mr. Bizarre raising his right hand, Mr. Metzger, Mr. Brito, Mr. Costello, Ms. Levinson, and Mr.
And
Aranda.
I have Mr. Gill is here with me, so I'll have him raise his hand, even if he may not speak at all, but just in case.
Thank you for that. Okay, Mr. Gill, Mr. Aranda, do you affirm to tell the truth, the whole truth, and only the truth, folks?
I do.
Yes.
I do.
Okay.
I do.
You've all been duly sworn. Let's proceed. Are there any preliminary matters with this record or with this appeal? I've read the entire record. It looks like a relatively simple issue for this case. Are there any preliminary matters, Mr. Campbell?
No, sir, Mr. Chavez.
Okay, let's proceed. Mr. Campbell, you are up first.
So I would like to have Ms. Levinson testify. I would like to have Mr. Costello testify, and then I would simply wrap up the appellant's position by referring to the record and to the appropriate EDO sections, if that's acceptable to you.
Absolutely. Proceed, sir.
So, Ms. Levinson, do you have a statement that you would like to make for the land use hearing officer?
Yes, I do.
Go ahead.
All right. This is for Mike Gill and myself. We are the owners of 7909 Kibo Drive Northwest. We have lived in our home for 12 years. Our home sits to the east of 7911 Kibo Drive. My husband and I chose this lot and this area because of its restriction on house height, setbacks from the front, side and back, and restrictions that the entire subdivision would remain as one-story, single-family homes that would preserve the views and uniformity of the neighborhood. Our subdivision currently has over 120 homes, many of those recently built or currently under construction. There is not one other home that has a finished grade pad built up as high as 7911 Kibo Drive. The pad at 7911 is almost 3 feet higher than our home, which sits at natural grade. Our lots are only 30 feet apart, so the terrain is similar and lot size is the only differentiation, and that is very minimal. So we cannot understand the need for a pad so high. The permit issued and approved for Mr. Islar's home will have his home sit 3 feet higher than our home, which is the nearest abutting home. There was no variance requested for this increase in height, as his home will be almost 18 feet and not 15 feet as the IDO requires. Mr. Islar had a home designed that originally had requested 3 variances, one for side yard, front yard, and garage setbacks that had to be submitted to the city because his architect stated that he did not know there were covenants and restrictions when he designed the home, and therefore they did not adhere to the IDO restrictions. It is clear that this time Mr. Islar and the city decided to skip the variance process for this increase in home height.
Ms. Levinson, let me ask you a question.
Yes.
The variances were issued under the IDO for setback requirements under the IDO, not for setback requirements under your restrictive covenants, correct?
Correct.
Okay.
Correct. There are, our covenants are older, and yes, it's the IDO. There are still 3 lots that surround Mr. Islar's lot, 1 to the west and 2 to the south. If Mr. Islar's 3-foot pad height remains, each of these lots will have to conform to the same height in order to have no future issues with runoff. This will mean that the uniformity of the neighborhood and the rest of our street will be affected by these homes all being higher than the 15 feet, and thus making our home appear to be sunken or sitting in a hole. Our other concern is that we have a basement, and if these surrounding lots, 4 of them, if they are so much higher than our lot, which is at grade per the restrictions that we had when we built our home, we will be the house to get all the runoff, resulting in a flooded basement. Mr. Islar's home will impact views of neighbors to the west of him and compel all future building in the immediate area to request variances for increase in home height because of the height of his home and pad. Many in our area have view decks on top of their roofs, and the added height of Mr. Islar's home can also impact those views to the east in our immediate area. Mr. Islar can lower his home height to comply with IDO by either lowering the grade or his actual home height, or per IDO, he needs to seek a variance to do this. Thank you.
Thank you, Ms. Levinson. Any cross-examination by anybody? There isn't a party opponent in this appeal. Apparently, Mr. Islar is not here. And I noticed that he did not submit any. Oh, yes, sir.
Mr. Chavez,
Hold on a second, Mr. Campbell. Sir, you raised your hand. Who are you?
Yes, I'm Salem Islar, the property owner, sir.
Mr. Islar. Hold on a second, Mr. Islar. Let me swear you in, okay?
I did, sir, but sure.
Oh, I'm sorry. I didn't put your name on my list. I didn't see you swear in either. So I'm going to ask you to affirm and tell the truth that you are telling the truth, okay?
Yes, sir, I do.
Okay, so you have been sworn in, and your full name is Salem Islar?
Yes, sir.
Okay. Now, Mr. Campbell, hold on, Mr. Islar. Mr. Campbell?
I would like Ms. Levinson to conclude by identifying and talking about some photographs that we've got ready to be queued up.
Okay, since she is still testifying, Ms. Levinson, why don't you finish your testimony because you are subject to cross-examination afterwards, okay?
Sure.
So,
All right.
so if we could have the photos starting with the 7909 Kibo put up.
Okay, and I note that this photograph is already in the record. It was submitted by supplementation by Mr. Campbell approximately, the 24th or so?
That's correct.
Okay.
So
This
Ms.
is-
Levinson, can you identify this?
Yes, this is 7911 lot, and that is our home next to it.
And does this show the
This shows the
The
pad,
earthwork?
this shows the dirt work after the second, yes, this shows the dirt work that currently exists.
okay. And
Ms. Levinson, may I ask some questions, Mr. Campbell?
oh, yes,
Okay, Ms. Levinson, there's a depression in the photograph of the grade. Is that the pad or is the pad over on top of the hill?
That hill is the pad.
I get it. Okay, thank you. Go ahead, Ms. Levinson.
and could we look at 7909 Kibo?
That is our home, which sits at grade, built 12 years ago.
And
it's,
where is it in relation to the to Mr. Islar's lot?
His house would be to the left, and it is, there's a 15-foot setback from our house to his wall.
Okay.
So 15
then,
away.
and then if we would scroll through the other photos, is
That's
this,
another, go ahead, Jack.
is this another view of the subject lot? Looking,
Yes,
and the next one? Another view of the subject,
yes,
the next one? Another view, we can move on.
that's a view from the back of the house of the lot toward the south. That would show the two other homes.
Okay, now I see the pad. Okay, good.
That would be from our wall to the west.
Looking at the raised pad, correct?
Correct.
All right, next one.
That's another lot in the area that is on Popo that is being prepared for the pad, and that shows the grade of that lot.
Are these numbered, Mr. Campbell?
They are not numbered. They have descriptions at the bottom.
They have addresses on the bottom.
Do that there for just a second. And this depicts another lot that's in the subdivision?
Yes, what we did was took photos of current homes in phases of construction and homes that have been here to show that the grade level on all of these homes, there's not another one as high as the one at 7911. And we're not, it's just, they're to the grade and to the height they were supposed to be per the IDO.
The next picture, please.
Again, a home on, I believe that, I don't see it on the screen, but that one is on Victoria and it is under construction. Oh no, that's Kayenta and it's under construction. Great.
Next.
A home on Casablanca, also in various phases of construction. Again, grade.
And within the subdivision, correct?
All in the same subdivision. There are approximately 120 homes. When it's built out, there will be 200 plus homes. Another home under construction, again, at grade.
And this is 6516 Jade Northwest.
Yes.
Okay.
And Ms. Levinson, how do you know these are at grade, at natural? And when you say grade, are you referring to natural grade?
Natural, yes. I mean, they're not 3 feet high, I guess is a good comparison.
Well, I guess my question is, are you assuming they are at natural grade based on the depiction in the photograph? Or do you have other information that you are basing your testimony on?
I'm basing it on what I'm seeing when I.
So your observations.
My
Okay.
observation, yes.
Thank you.
Our observations. It was Mike and myself that went and did our research.
I understand.
Okay, next photo.
This one is a large home being built in the same subdivision again on Onyx Court under construction.
Next photo.
The same street and a smaller home under construction. This one is again on Victoria on grade with the street and under construction.
So hold on a second. You said something a little different. You're saying that this is on grade with the street.
Well, I'm not sure, natural grade.
Hold on, let me speak and then you can speak. It's
Sure.
really difficult for the court reporter to get both of us speaking at the
All
same
right.
time. So I guess my question is, you've just testified that this is street grade. Is the street grade natural grade?
I'm assuming, no, natural grade is natural grade.
You don't know the answer.
I'm not
Okay.
sure. I don't know
Okay.
if it's the street or the curb or the sidewalk.
I understand. I'm just trying to understand your testimony. Thank you.
Okay.
Next photo.
Victoria, this house is actually next to Marcoux under construction.
Next photo.
This is a house that was built the same time as our home on the street to the west of our home. Again, built to natural grade, but showing that the driveway actually slopes down a little.
Next photo.
This is the original photo that of lot prior to any work being done of 7911 Kibo.
Next photo.
This is
Can we, turn it. There.
okay. This is 7911 with lot work.
Okay, thank you. That's all I have for Ms. Levinson.
Thank you, Ms. Levinson. Mr. Islar, would you like to cross-examine Ms. Levinson? You have a right to ask her questions. I know you're not an attorney, but you can ask her questions at this point. Now, I will give you some time to make your arguments. In fact, you have more time than Mr. Campbell. You can present your case, and then at the very end of the appeal hearing, you can give me a rebuttal argument, a quick 5-minute rebuttal argument, 10-minute rebuttal argument. But for now, this is only your opportunity to ask questions, okay? Not to argue. So if you start arguing, I will have to stop you. And I always tell that to to lay witnesses because they want to get into an argument right away. But this is only your opportunity to ask questions of Ms. Levinson regarding her testimony. Okay, sir?
Thank
Go
you,
ahead,
sir. Mr. Chavez, yes, good morning, Mr. Chavez. May I just say, my computer's going to restart in 9 minutes. So I'll just make a statement, and I'm going to defer to the city experts that have made their decision. So I have no desire to enter into a confrontation or any questions.
So, Mr. Islar, you're doing what I admonished you not to do. This is your opportunity to ask questions of Ms. Levinson. Now, if you believe that if you want to ask questions, but you believe that time will be cut short because of your computer rebooting, we can take a break. I'd rather have you understand and ask questions if you need to, rather than you rush through this because your computer might be rebooting. So what we can do is we can take a break for 5 minutes now, let your computer reboot if you can manually do that, and then we can start over again. What would you prefer to do, sir?
Well, sorry, I'd only like to correct 2 inaccuracies. I don't have
No.
any.
Again, this is only your opportunity to ask questions.
Okay.
Now, I will allow you to make an argument,
You're okay.
okay? But that's not this time.
I have no questions, sir. I'm sorry. I have no questions.
No worries. I understand. This happens all the time, Mr. Islar, so don't worry. Mr. Brito or Mr. Aranda, do you have any questions for Ms. Levinson?
No,
I personally do
No,
not
I do
at
not.
present.
Okay, Mr. Brito first.
Mr. Chavez, I do not. Thank you.
Thank you. Mr. Aranda?
Mr. Hearing Officer, I do not have any questions for Ms. Levinson. Thank you.
Okay, wonderful. Well, let's proceed then. So, Mr. Islar, now this is your opportunity to present your case. I don't know whether you're still on. Is he on, Mr. Moya?
Mr. Chavez, no, looks like he's no longer on.
Okay, let's do this. I don't want to have any due process issues pop up later. So I'd rather proceed with an abundance of caution. Mr. Campbell, if it's okay with you, I'd like to take a break. Can somebody, Mr. Moya, can you get, I hate to have Mr. Moya do it. You'll be dealing with the Zoom hearing. Mr. Brito, could you get Mr. Islar on the phone and let him know that we are going to take a 5-minute break until his computer reboots, because I do want him back inside this hearing. Okay? Mr. Brito, can you do that for us?
Mr. Chavez, I do not have Mr. Islar's contact information. I'm happy to do it. If
Oh, shoot. Okay.
someone could email that to me, I'm happy to give him a call.
Okay. Mr. Aranda, do you have Mr. Islar's contact information? His email?
Unfortunately, I do not. This would be information resigning with our zoning review. Let me see what I could do.
Okay.
Let me
Yeah,
start
we'll have to call him instead of send him an email because
No, I know.
rebooting his
Yeah.
computer.
Let me take a look and see what I got here, boss.
Let's what we'll do is we'll take a quick break.
I got his phone number.
Oh, good.
It's
Mr.
on
Campbell,
the,
could you call him, Mr. Campbell?
You're the man, Jack.
I'll call him.
Okay, let's
Thanks,
take a
Jack.
5-minute break and we will come back on at exactly 9:30. Is that good?
So
Okay.
when we take this break, we just stop the video or do we sign back in?
You'll have to, you can stay on or you can
Go off and come back.
terminate the link and sign back in. It's up to you, but
All right.
we will start. I'm going to leave mine on and we will start again in 5 minutes. Okay. And I'm going to put a
Alrighty.
little tab. So yes, sir.
Can I ask a question? If Mr. Islar cannot get his computer to work, there is the option of just calling into this Zoom
He
meeting
can
with the
appear
telephone.
telephonically as well.
Good
Correct.
call.
Maybe we can give him that option if the computer refuses to work.
There,
call.
the instructions are on the email that he received. So, there's only so much I can do. I want to give him every opportunity to be a part of this hearing so that we can deal with any appellate issues here and now. Okay? Thank you, folks. We'll start at 9:30 or let's do 9:35. It's already 9:27. Bye-bye.
Mr. Chavez? Are you there? Mr. Chavez?
Yes, sir.
I called Mr. Islar's number listed on the building permit application. There was no answer. I left him a message telling him he could phone in and join if his computer didn't reboot.
I'm here, sir. Thank you.
Oh, there
okay.
you are. He's back.
I apologize to everyone for technical difficulties.
Are you okay now, Mr. Islar?
Yes, thank you, sir, Mr. Chavez.
Okay, we will go on the record in 4 minutes. I let everybody know that we would take a little break until 9:35. So I want to make sure we get everybody back on.
I apologize for that delay.
It happens, Mr. Islar, no worries.
That's part of our lives now, technical glitches.
That's correct. We are off the record technically, correct, Miss Rebecca? Rebecca, can you hear me?
I do. I forget to unmute myself. No, we're not
Okay.
on the record.
So we're off the record. We're still on the Zoom YouTube live feed. So, but we are technically off the record for our court reporter. Mr. Biazar, back on.
Yes, sir.
And Mr. Islar is here. Mr. Campbell is here. And Mr. Campbell's clients are here. Mr. Brito, are you here?
I'm here.
Mr. Aranda, you are here. Okay, Mr. Moya, we are proceeding. Are we back on the YouTube or were we always on?
We were always on, so we're good to go.
Okay.
Mr. Chavez.
Okay, so Rebecca, let's go back on the record. We are back on the record, and where we left off was I was asking Mr. Islar if he wanted to cross-examine the witness, Ms. Levinson. He did not. He declined. We lost his feed. He is back on. Mr. Campbell, do you have more witnesses?
Mr. Costello,
Mr. Costello.
if you'll go ahead.
Yes. May I begin?
You
Yes,
may.
sir.
Let me read a short statement in the interest of time. First, to introduce myself and why I was selected as a witness. My name is Marco Costello, that's on the screen. My wife and I own a home in the neighborhood on Victoria, 1 street south of Kaipo, since 2007. I wrote the bylaws of the Molten Rock Neighborhood Association in 2010 and was the president of the Molten Rock Neighborhood Association from 2010 through late 2017. Both my home and the home on Kibo are part of the Molten Rock Neighborhood Association. Concurrently with my role as the president of the Molten Rock Neighborhood Association, I was a board member of the Volcano Cliffs Property Owners Association, usually referred to as VCPOA, a body of property owners that had an interest in both SAD 227, which is the current Molten Rock neighborhood, and SAD 228, which is currently called Petroglyph Estates. As part of my involvement in both the Neighborhood Association and the VCPOA, I learned a little bit of the history of this neighborhood that dates back to before my actual living here. The city required covenants and restrictions for homes to be built in SAD 227 at the time when the building started. The VCPOA administered the enforcement of these covenants and restrictions through the Architectural Control Committee, or ACC, and reviewed all proposed building plans in SAD 227 and issued an okay to the city before the city would issue a building permit. I was not formally a member of the ACC, but was involved in several cases and was always informed when the ACC had an issue.
Mr.
Like
Costello,
Mike
I'm going to
Gill and
interrupt
Sandy
you.
Levinson, my wife
Mr.
and I
Costello,
bought a house.
Mr. Costello, let me interrupt you a moment. I apologize. The ACC and the covenants are not relevant in this hearing.
I
So
will get to that in a moment.
please be quick because there are time constraints.
I understand.
If it becomes irrelevant, I will hold everybody to the time constraints. Thank you.
Let me finish and then explain why that is relevant. Mike Gill and Sandy Levinson, my wife and I bought a house in the subdivision relying on the zoning, which regulated the height of structures, setbacks, etc. We knew that we did not and would never have neighbors with a multi-story home right next to us. These restrictions were important because it gave us the feeling that our neighbors were not right on top of us, even when we live within the city limits. I have lived in the subdivision for over 13 years and no other home has required a lot elevation to be raised 3 feet. I disagree with Mr. Islar, won't be able to build on this lot without the raised elevation because the street has stormwater drainage, and for all other homes that have been built in the neighborhood, being just slightly above curb height, which itself is above street level, has been deemed acceptable. Even if the elevation of the lot has to be raised somewhat for drainage, I don't think that Mr. Islar's house has to be 15 feet in height on top of the pad. He can lower the height of his house to accommodate the elevation of grade so that he will not violate the zoning. I agree with Ms. Levison and that Mr. Islar should be required to seek a variance. To get back to why the covenants and restrictions are important is that the IDO was actually written to codify as city rules, almost exactly to the word, the exact covenants and restrictions that were in place when we bought the house and when Ms. Levinson and Mr. Gill built theirs.
Okay.
Thank you.
Thank you, sir. Mr. Islar, would you like to ask questions of Mr. Costello?
No, sir. Thank you.
Okay. Mr. Aranda,
Yes, sir.
do you have questions for Mr. Costello?
I do not have specific questions for the witness, Mr. Hearing Officer. Thank you.
Thank you. Mr. Brito, any questions?
Mr. Chavez, no, thank you.
Okay. Mr. Biazar, do you have any questions for Mr. Costello?
This is Shahab Biazar, Mr. Chavez. Just had a quick question. Was there anything about requirement of grading and drainage plans under your covenants?
To my knowledge, the drainage plans simply needed to follow whatever city rules were in place. There were no explicit rules in the covenants and restrictions regarding drainage.
Thank you, sir. That's all I had.
Thank you, Mr. Biazar. Thank you, Mr. Costello. Mr. Campbell, do you have more witnesses?
I do not.
Okay, thank you. So, Mr. Islar, this is your opportunity now to present your case.
Thank you, Mr. Chavez. Since I'm not a subject matter on the code, but I have other comments, can I defer to those of the city, Mr. Aranda, Mr. Biazar, Mr. whoever, is involved with the decision to speak their piece and maybe allow me 2 minutes at the end, because I was not involved in this decision-making, sir, nor do I have the expertise, as you pointed out, about what is natural grade, finished grade, below grade. My future is in your hands. I'd like to have the experts speak to why they made the decision they did, please, sir.
Mr. Islar, thank you, but don't put your future in my hands.
Okay.
Anyway, Mr. Aranda or Mr. Brito or Mr. Biazar, which one of you want to go first? Because I have a lot of questions.
Okay. I think what I can do is give a very brief historical overview as to how we got to this point. And then what I would like is for Mr. Biazar to speak as to why we required the actual 3 foot of fill in order to facilitate grading and drainage. Is that pleasurable to you, Mr. Hearing Officer?
I have no pleasure in this, so
okay.
It's up to you how you want to proceed. My concern, Mr. Aranda, and if you could focus on this, my concern is I would like to know what what regulations specifically in the DPM or in the flood hazard drainage control ordinance expressly allows you to prevail or trump the IDO. I saw language that general life and safety issues, that doesn't cut it.
Yeah, no, it's a combination of policies and regulations. And I could kind of start going through that if you'd like.
Well, it's up to you, but that's my concern with this.
Yeah, no, totally understood. Totally understood. So, okay, so when the roads in SAD 227 were constructed, instead of going the extra expense of trenching or blasting through the volcanic basalt rock to install underground utilities, as much surface soil was excavated as possible. Utilities were then basically dropped down, covered with fill, and then constructed the road system on top of that. That situation basically created a situation where the roadways throughout the SAD, including this particular roadway, were raised to an elevation higher than many of the abutting lots. That situation created a number of issues and potential liabilities that the planning department has to navigate. These are health and safety issues, such as the potential for flooding and improper drainage at a large scale. These tend to led to conflicting regulations within the IDO and ROA 1994, and the potential for encroachment on the entitlements of property owners in 227 and SAD 228. So that's kind of the preface of how we got to this particular situation. In terms of authority, I will just go ahead and say table 611 is going to be relevant because that basically shows that this is an administrative process, a grading, drainage, and paving approval. When you look at 62B1C, 62B1C2 specifically, the ZEO has responsibility for making formal determinations as how this IDO applies to specific situations, proposed development projects, and parcel of land. That particular,
Mr. Arana, doesn't that section, isn't that a broad authority that's been delegated to you? Isn't that discretion to interpret the IDO rather than to allow or to make administrative rulings regarding applications under the IDO?
Again, that particular explicit language says how this IDO applies to specific situations. I intend to interpret that as how it's applying, not necessarily how I'm interpreting it, a particular rule. It's how it's being applied for a specific situation. When you continue down to 64A, that's the part where we talk more about interpretation. And again, that grants the ZEO authority to interpret this IDO, including the authority to determine its applicability to specific properties or situations.
So I guess my question regarding that is, and I don't want to get confrontational with you.
Oh yeah, that's fine.
I have great respect for the planning department staff.
Yes, sir.
My concern is that there are clear regulations in the IDO.
Yes.
And there are exceptions to those regulations, and the variance process for this issue is the exception for the IDO. But you've decided to ignore the variance process and issue an administrative decision because you believe that you have essentially created a taking situation under the Fifth Amendment. You've made the ruling that Mr. Islar cannot develop his land at all, similar to a takings under the Fifth Amendment. So you administratively ignored the requirements for Mr. Islar's height requirements because of generally health and safety. And my concern is that that's a slippery slope to me, using health and safety to grant administrative variances when there is a procedure for those administrative variances. I don't know how it gets you to ignore the administrative procedure. And that's what I'm trying to understand, because I went through the flood hazard drainage control ordinance, the entire ordinance, because you referenced it in your argument. And I could not find any express language that allows you to ignore the IDO. And I can't find any language in the IDO that allows you to ignore it.
I would say we're not ignoring the IDO. I say it's being applied. Let me explain how we came to the decision of why a variance was not applicable in these particular cases. So when you go to the VPO standards argument, which requires the variance, when you're looking at 36E3CB, and we're talking about,
I'm sorry?
36E3CB. This is the VPO standards discussion. When we're talking about granting a variance, you're talking about going up and above what the regulation allows. Mr. Islar is proposing a 15-foot structure with a 3-foot required fill. He's not going up and above what is actually allowed by the regulation. This is how we ended up erring on the side of, well, this looks more like an administrative taking, because he's not building an 18-foot structure. He's building a 15-foot structure upon 3 feet of fill. And basically when this whole process kind of evolved in, let's say, August of 2019, we had a situation where the ZEO at the time made a determination in consultation with the planning director and the city engineer that the engineering challenges posed by SAD 227 and SAD 228 warranted placing the primacy of health, safety, and general welfare standards, and therefore the requirements of ROA 1994, those were considered more restrictive than the VPO standards included in 36E2. And therefore, based upon the decision of the previous ZEO, that took precedence.
Wait, I'm sorry to interrupt. And
oh, I'm sorry. No, it's okay. I'm sorry for
restrictive. I don't understand how the general requirement that you.
It's a life safety welfare regulation, sir.
Let me finish.
Okay.
How is it more restrictive than a general requirement that you fulfill the health and safety and welfare of the general public? How is that language more restrictive than an IDO regulation that expressly requires 15 foot from natural grade or a variance? How does that general language become more restrictive? I don't see that. And then that just, to me, that's,
I would say, yeah.
Slope to give you discretion to do whatever you want, anytime you want, if you say, well, this is a health and safety and welfare issue. That's my concern.
Fully understood. And I would say the fact that it is a general health, safety, welfare regulation in of itself gives it primacy over a regulation restricting something such as views.
That's what I thought you were going to say. Okay. Mr.
Ron,
I have some questions for you.
That's fine.
Do you stipulate that the natural grade is 5321.4? Mr. Campbell argued, and he showed documentation, and I think Exhibit 2 or Exhibit 3, I can't recall which one, that the natural grade was 5321.4. Do you stipulate that number? Or Mr. Biazar maybe can answer.
I would have our city engineer specify if that is the correct height. I would rather have him.
I will separate and ask Mr. Biazar those questions, and I don't want to stifle your presentation, so go ahead and finish up if you like, or proceed.
Okay, thank you, sir. Okay, let's see, going back to where I was. The next piece in terms of the protected views. So again, you know, the previous ZEO in consultation with the city, with the city's planning director, as well as the city engineer, we looked at this, and we also determined we had to figure out an administrative process. So it wasn't just outright ignoring the variance process, it was creating an alternative administrative process by which hydrology would be involved in terms of reviewing to ensure that there was proper drainage flow on developed lots. They were to fill out a form specifying what that need was. The form was thereby approved. The form was reviewed by our legal department. The process was also reviewed. There didn't seem to be any issues with implementing this particular process until this one application
What in the
goes
IDO,
through.
Mr. Aranda, what in the IDO allows the planning department and the engineering department and the zoning department to create an alternative administrative process? Where has the city council delegated that authority to you folks? Because I looked for that too, and I couldn't find anything. I thought that the city council only delegated to you the authority what's in the IDO, nothing else.
Again, I'll go back to 6.4a. I'll just keep beating the drum on 6.4a. It requires, that's a broad authority that's granted to interpret the IDO, including the authority to determine its applicability. And then I can go back again to discuss 6.5c, which is grading, drainage, and paving approval. All applicable provisions of 1416.6.4 apply unless specifically modified by the provisions of this subsection, the DPM, Article 14.5 of ROA 1994. In case of a conflict with any standards in this IDO, the standards and procedures of the DPM or the flood hazard and drainage control ordinance shall prevail. This was more in terms of how we came to the point of applying the requirements of the flood hazard and drainage control ordinance over the IDO. In terms of the authority to create a process, I go back to 6.2b1c2 again. Again, that's granting the ZEO responsibility for formal determinations as to how the IDO applies to specific situations, proposed development projects, and parcels of land. Utilizing that authority is what granted the previous ZEO along with the director and the engineer to determine that it was required to create a process. We can also look at IDO 18B is another section that is granting authority in terms of relationship with other rules and regulations.
I'm familiar with 18B too. Okay, thank you.
Yes, sir. I appreciate that.
Anything else, sir?
No, I would just like to finish by saying once again, you know, it is clear that the DPM and drainage ordinance are clearly more restrictive, again, as they are based on health, life, and general welfare. Even though they're general, they are clearly more restrictive because those standards are necessary to facilitate development that is safe, that protects the safety and the general welfare of the public. And that's basically how we came to that decision. So I will go ahead and turn it over to the city engineer to just discuss engineering.
I have one more question. Question for you, and then Mr. Campbell may want to cross-examine you before we move on.
Sure.
With regard to the flood ordinance, you reference the health and safety of the general public.
Yes.
And the welfare of the general public as the more restrictive language that allows you, that gives you the authority to create this administrative process. What is the general welfare? What is the health and safety issue here in your mind that gave you that triggered this discretion?
I would say the general health and safety is understanding that a majority of these lots are underneath the road elevation. That situation creates multiple potential for flooding and drainage in terms of not only just from the roadway itself going onto abutting properties and it becoming a taking. The fact that you have these structures lowered than the roadway, it makes them virtually undevelopable without fill. In terms of the safety and health issues, while there's potential, if that lot is not graded correctly, properly, the drainage then has the opportunity either to flow to their neighboring properties, to properties behind them, et cetera, et cetera. So to us, that is the clear threat to health and safety, is the potential for drainage and flooding upon either the neighbors or basically fomenting rendering the lot virtually undevelopable at that particular grade, at natural grade. And that's the challenge with the natural grade.
So if that's the case, doesn't the variance process provide you the remedy, or provide the city with the remedy and the applicant with the remedy to deal with those issues? It seems to me that there is a clear variance process for this. And it's It's so
So-
clear to me. And let me finish. So
Oh, yeah, I'm sorry.
if the remedy is not a variance, then why is there a variance process? If you're going to create a third process, because there's the first process is they apply and they build 15 feet above natural grade without a variance. Second process is they apply for a variance, either get it or get denied a variance. And now you created a third alternative process that is unclear to me at the very
Right.
best, but you created this process to circumvent the variance process, it sounds like. Because it seems like you can achieve everything that you've talked about to protect this alleged health and safety and welfare issue, which I'm not sold on yet. There's already development out there, quite a bit of development. But it seems like you've relegated the variance process to a process that's ignored. Maybe ignoring is kind of too strong of a word, but
Yes.
I don't see how do we use the variance process if not for this exact situation?
Let me, Mr. Hearing Officer, let me explain to you if you go into 36E2 and 36E3CB, it really gives an explanation on kind of what,
I think you need this.
I'm sorry, I have the wrong one, 66M and 66M1. It talks about the applicability of the variance on this particular thing. And let me just clear up real quick. This is kind of a temporal, a stopgap process. We currently have, going forward, there's an amendment process where some of the language in the VPO is going to be clarified. So this wasn't meant to be this wasn't meant to be a process that's going to continue immemorial. It's basically a stopgap to get us through to where we got to go to make the fixes in the legislative language to then foment development. So I'm going to jump back.
That's totally unacceptable because it's the IDO that's currently in existence. You can't.
That's correct.
You can't apply. Wait, let me finish. You can't apply retroactively a future bit of legislation to this situation. You can't do that. That's unlawful, and so I won't even entertain that thought.
Understood. So
you said, and I'm sorry, I'm
no,
not
it's fine.
angry. I'm just
no one's angry here. I mean, this is something that we need to figure out. We fully understand. This is a challenge we're dealing with.
66M allows you something.
So back to 66M. So when you go to the applicability of the variance EPC, which is what's going to be required if we were to send every single homeowner to basically who wants to build and is under grade is going to have to apply for a variance in SAD 227 and 228. That's what was the determination of the previous ZEO. And so when you go into 66M1C, this subsection 141666M applies to requests for variances to the 15-foot structure height limit in the height restriction sub area of the Northwest Mesa Escarpment, BPO2, for one of the following variations in structure height. 1, variance for up to 4 feet of additional height for non-residential structures may be allowed in order to screen rooftop equipment. A variance to allow up to 26 feet above natural grade may be granted for low density residential developments of 1 dwelling unit per acre or less that are set back a minimum of 200 feet from the escarpment face, i.e. 9% or greater slopes. Now, based on the determination of the previous ZEO, this particular application doesn't fit either of those particular criteria. And so that's how we got to this particular situation, being that building a 15-foot structure, which is based within the VPO allowed height, is not up and above the required 15-foot height. That was the determination that was made, and that was how we got into this quote-unquote slippery slope of creating a process to address that particular regulation.
Okay. Mr. Camp, are you done, Mr. Aranda?
I am, Mr. Hearing Officer. I appreciate that.
Thank you. Mr. Campbell, do you have any cross-examination questions? You got to unmute, sir.
I'm unmuted. Mr. Aranda, would you please look at section 3.6C?
Mhm. Or okay.
Would you read 3.6C?
Yeah, 360 deviations and variances. Administrative deviations from the VPO zone standards are not allowed. Variances from these standards are only available pursuant to 14.6.6N variance ZHE or subsection 14.16.66M V variance EPC, which require a public hearing.
Thank you. Nothing further.
No more questions, Mr. Campbell?
No, sir.
Okay, thank you. Mr. Arana, who else wants to testify? Mr. Biazar, did you need to testify in this hearing?
Yes, sir.
Okay, good. You are sworn in, sir. Go ahead.
So this is Shahab Biazar, city engineer. I just want to give a quick background on SADs. So SADs, they were all platted lots without any improvements. So in order to be able to allow anybody to build houses, SADs are created to basically come in and create master drainage plan, master utility plans, and all the improvements needed in order to do in order to come and build the houses in the future. So as part of that, and what's different between SADs and regular subdivisions are they're not mass graded, the lots, because the city does not want to spend the time and the money to assess the lots by coming in and grading all the lots. So what they do, they come and put all the curb and gutters, utilities, drainage, improvements within the street in order to for the house owners to come back and build their houses. But with the SADs also, what we have, it's drainage master plans. So the drainage master plans basically tell us that how these lots will be draining in the future. So as part of that, when they come in for building permit, we do require grading and drainage plan. And one of the reasons that the grading drainage plans are submitted, so exactly not to flood your neighbors. In this case, I guess it was testified that at 79, the adjacent property owner, they have basement. More reasons for them not to get flooded. You want that water to get to the storm drain system in the street. So basically, when they submit the grading plan, they are supposed to provide minimum amount of fill in order to achieve that. And under the section IDO page 3, section 1-7B, it does allow the city engineer to require grading and drainage plan prior to building permits. So based on that, they did submit a grading plan and we looked at it, and they had minimum slopes in order to get the water to the front. And I guess there was a question of 3-foot fill. I think it was a question, what is a natural grade? So this lot drains about 2 feet from the front edge to the back. So if I had to say the natural grade would be 53.22, and the finished floor is 53.24.50, which is 2.5 feet of fill in order to get the water.
Mr. Beazer, I have a question before you proceed, because
Sure.
I apologize. I interrupt people all the time because
No,
I
please.
have to ask the question as you talk, because I'm getting old and I start forgetting my question.
No, please do so, sir.
So Mr. Campbell has argued, and he provided documentation that the natural grade for Mr. Islar's pad site is 53.21.4. It sounds like you're agreeing with that within a half a foot.
That is, well, it is very close. Yeah, within half a foot or so, yes.
Okay, so you stipulate
So
that.
yeah, we usually look at natural grade, basically the center elevation of the pad, because obviously there's not full. I mean, yeah, it's not a flat site. And
Right.
Say that again. I'm sorry, I didn't understand you.
Which part?
That's
You were talking about natural grade, your last sentence.
So the natural grade, basically, it's the average elevation between from one end to the other.
From the center, taking it
Yes,
from
sir.
the center out.
Yes, sir.
Okay,
So basically, so drainage plans were created in order to have some guidance in how these lots would drain, and the storm drain system in the streets were built based on that. I'm just on record, not all the lots drain to the street. There were some situations like in SAD 228 where the lots did drain to the back, but there were provisions. There was channels built in the back or swales built in the back to allow for that. In this situation, this lot is supposed to drain to the front. That's how this drainage plan was created. I think I was going to also go back to, I know there were several lots were brought up during the presentation, and I just went and looked at one of them quickly, 8015 Victoria. So I went and looked at the grading plan for that, and there was a 3.5 foot fill on that lot from the natural grade. So I just want to put that on record. I just pulled it up real quick, and I could bring it up on the screen if you need to.
What was the address for that one?
8015 Victoria, sir.
Okay.
So the lots were not built on grade or natural grade. So they had to, and like I said, I looked at the center line elevation, and there was like nearly 3.5 foot fill on that lot in order to get the water to the front. I didn't pull up every single lot that was brought up during presentation, but
I assume that there was some fill on most of those lots. I can tell. I've developed a lot of land in my time, and I started doing that when I was in my teens, and I can tell you I can see it pretty easily. So, I guess my concern, Mr. Biazar, and I have great respect for you, sir. I know that you're a wonderful engineer. I'm not an engineer, and so I don't profess to be. But my concern is that we're using the FF, we're using the fill grade for the natural grade. And it seems to me that you stipulated that the natural grade is 5321, at least 0.4, maybe 5322. So how do we get to the 5339.5, which is the finished grade, right? That's the
yes,
finished
sir.
grade,
and
without a variance.
So, Mr. Chavez, I'm not saying that 5320, the finished floor is not the natural grade. That's for sure.
I understand that, but the finished grade is going to be 5339 with the 15 foot. That's going to be the total height of this building at 5339, which is 3 feet over what's allowed without a variance. And it seems to me the IDO specifically takes this into consideration and says you can get a 4 foot variance, up to 4 feet in variance, up to 19 feet, I think it says, total for height. And so that's a 4 foot variance essentially in this situation. But everybody is pretty much, to me, it looks like we're just bypassing the variance process. And we're saying, well, we've determined that this is the city's fault because we created a street here that's above natural grade. And so this is our gift to you to repay you for our mistake. And I know I'm indulging in language here.
Sure.
I'm concerned that we're bypassing a process that the city council set up. And the city council is the only entity that has the authority to set these processes up. And there's a process clearly demarcated for this situation, for this exact situation. And it's the variance. And it's not a variance through the zoning hearing officer. It's a variance through EPC. And it looks like that for some reason, somebody doesn't want to take it to the EPC for a variance, when it seems to me that's the only avenue there is for this situation. And I'm trying to understand the reason why we're going that route. And I'm not convinced that this alternative process is appropriate, because I can't find anything in the IDO that authorizes this alternative process. There's nothing in the flood hazard drainage control ordinance that authorizes it. Certainly there's the health, safety, and welfare language, but that language is in almost every governmental ordinance that's enacted. And so I don't know how you can hang your hat on that. And that's where I'm trying to narrow it down to that issue.
I understand, Mr. Chavez. Now, I'm going to leave the code enforcement
Okay.
regulations to code enforcement, and I'm going to talk to specifically to drainage requirements and how we got here. And that's what I'm here to testify on, and just talk about what the SADs are all about, unfortunately. And it does create conflict in our regulations. That's for sure. I mean, if it was a regular subdivision, these lots were already mass graded. There were retaining wall built. There could have been a 7-foot fill on natural grade, which was, pre-approved, and they were all graded. And when they come and build, they do go 15 feet from finished floor. But like I said, unfortunately, SADs are a different animal, and it makes it hard for art to regulate them. And I'll leave it at that.
This isn't the only SAD in the city, right? I mean, there are special assessment districts throughout the city, correct?
Yes, that is correct. And most of them are the same. Most of them are built out, but SAD 227 and 228 are still, there are plenty of lots left. There are lots that we do 8 feet of fill, which because they fall 15 feet from one end to the other. So, I mean, so that should not, basically the nature of SADs, unfortunately.
Right. Thank you, sir. Are you finished? Did you have more?
Yes, sir.
I didn't mean
that's it.
To run your testimony.
No, I'm done, sir.
Okay, thank you. Mr. Campbell, do you have questions for Mr. Biazar?
I do not.
Okay, thank you. Mr. Brito, are you there?
Yes, Mr. Chavez.
Is there anything you'd like to add? You saw where my concern is, and I know you've appeared in front of me for at least 15 years now, so you understand my concern here. If you can address that, I'd appreciate it.
Yes, and I believe that planning staff's explanation about why this was done do take into account, section 18B, the allowance for the ZEO to determine how regulations and requirements are applied in specific situations, the confluence of the grading issues created by SAD, development of adjacent infrastructure, and the unclear language about the VPO height restrictions all came together for that, pun intended, perfect storm where we have disparate parts of city government that were not fully coordinated in terms of the development of the SAD, the drafting of the standards from the previous sector plans that were incorporated into the integrated development ordinance, all came to a head with this subdivision in this area and this lot in particular. And what planning staff did was taking into consideration all these factors, came up with a process to allow property owners to develop according to their legal entitlements of their underlying zoning, while still respecting the intent and applicable standards of the IDO. And so when Mr. Aranda talked about how the previous ZEO worked with code enforcement and hydrology to create this process for only the pad site to have the minimum amount fill necessary for proper and safe drainage, while at the same time requiring adherence to the regulations of VPO2, the Northwest Mesa Escarpment View Preservation Overlay, to protect views into and out of the monument It was and is seen as a way to accommodate all of these different factors. And we have had great success in applying these for other properties in the area, only requiring the minimum amount of fill necessary only for the pad site, so that those views into and out of the monument are preserved.
I understand your dilemma, but here's my dilemma. I mean, I work for the city council, and my job is to determine whether or not you've erred, and I can't see. I just don't, for the life of me. I can't agree that the health, safety, and welfare language in the flood control ordinance gives you the authority from the city council to create this alternative process. And whether you've used this alternative process before, boy, I don't even want to know. But it's been, it's been appealed now, and I have to deal with it with this appeal. But I can tell you right now, my recommendation is very clear to me, and I'm going to deal with this quite in depth. I think what you're doing is arbitrary and capricious. I don't think there's a process for you. I think this alternative process is certainly, you folks have made it the best process possible, and you, by bringing in all the other entities to review, but it doesn't allow for it in the IDO. You have to follow the IDO. You can't just say, hey, there's not a process for this, so we're just going to do it on our own, and we're going to try and provide safeguards here, but we're going to do it administratively. If you don't agree that the variance procedure is appropriate here because of the language in 6M, 66M, then that's for the EPC to decide, because it needs to go before the EPC. And then the EPC can decide that issue, because I saw language in 66M that would allow the EPC to have some discretion. But I don't see, Mr. Brito, I'm concerned that this alternative process is just not authorized in the, and I'm going to look a little harder, but I spent the entire weekend reviewing all these ordinances, because this really gets to my craw. And I'm just, with all due respect, I don't like this process. It's because it's not authorized, and it's just created. And I normally don't say these things during a hearing. I usually wait. But boy, I tell you, steam's coming out of my ear, my ears for this process. It worries me, because it can create worse cases when you folks are doing it administratively, ad hocly like this. It worries me. That's all. But I don't want to stifle your presentation. Please proceed.
Oh, Mr. Chavez, I have nothing further. Thank you.
Okay. Mr. Campbell, do you have questions for Mr. Brito?
Do not.
Okay. Mr. Islar, this is your opportunity to rebut. Now, you heard me. I reviewed the entire record. It's remarkable to me. And I've done my due diligence. I reviewed all the ordinances that were cited by all parties in this appeal. You didn't make a presentation, but you can make a presentation. I will take it into consideration, because technically I haven't made a decision, but I want to hear what you have to say. I think it's important that you get that on the record, sir.
So thank you, Mr. Chavez. And thank you, Mr. Aranda Biazar Brito, if I'm pronouncing those names right.
You got them all right.
Sure, I would never contradict the city. I'm not the expert, nor are those opposing me on grade, natural grade, finished grade, as you brought out. I only share these points, please, and then I thank you for your time. Just to correct some inaccuracies, I never asked for a side yard variance. That keeps being brought up. You will find no record of a side yard variance. It doesn't matter.
I saw a variance in the record that was issued.
Yes, sir. That would be the front and the garage, those two.
Right.
But
Those
the
3
sides,
foot variance.
but the sides keep coming up, but that is inaccurate and not the truth. The second statement made that I decided to skip the process. Sir, how can a citizen of the city decide to skip the process? I have no idea what was going on. So please, just when you make your decision, I did not decide to skip the process. If I
Mr. Islar,
did,
I'm not holding you at fault to any of this. I understand that decisions are being made with the city and not you. Certainly, I'm not impugning you at all. Okay. So
Thank you.
if it sounded that way, my apologies.
no, not by you, sir. It was said that I and the city decided to, I did not, how can I? I don't even know the process. I did what the city asked me to do completely. And then the third inaccuracy, the third inaccuracy is that, as you can tell, I am not 18 foot above the curb. Most of that fill was to bring me up to finished grade and then my 15, just so if we want to be accurate, if that matters to you, I'm not 18 foot above the house or any other house there. A lot of that, almost 2 foot, was to bring me up out of the hole. But Mr. Chavez, I just conclude with this. I paid my fees, I filled out the application, I did everything the city asked me to do. I don't know these gentlemen, they're experts in their field. They made a decision, but the impact is going to come to me. Do I repeat this process? Do I open up another permit fee, pay another thousands of dollars, and have to repeat this when it's said that I can't, the grade is the grade, otherwise it'll drain out and impact others. Isn't that the most important thing? I do actually understand your position. You're trying to find the legal clear-cut ruling for this. And maybe that's a process for you gentlemen before the next case to review and conclude and consider. But the city gave me an approved building permit on June 1st. I can't use it. I paid thousands of dollars and I can't use it because my lot doesn't look like all the other pictures, but my lot is different. And as the gentleman Biazar said, there are other lots that have fill. And so we can't compare are all lots supposed to look alike to the untrained and uneducated eye? Well, it looks too high. Is it that, sir, or should water drain into someone's basement or someone's yard?
I don't think that's the issue here, sir. I think the issue here is whether or not you should have gone through the variance process, because there is a variance process for this exact situation. And there's a test for that variance process. There's a multi-pronged test. And part of the test is, how the situation was created, whether you created the situation, and it's clear you didn't create the natural grade. And so it's clear the city created the streets. So, I don't want to decide on a variance question, but it seems to me that because there's a process set up that hasn't been followed, that's the issue here. Okay.
Yes, sir. And I acknowledge, I understand your dilemma. I'm simply saying I had no part in it. And to repeat this process, couldn't it be resolved before issuing the next permit, not one that's already been issued in good faith? Because I'll conclude with these two things, sir. I would have gone through the process if the city said back during review time, you need to go through, sure. But I tell you who will be there to contest me on that process, the very ones here today contesting this. I will be contested for everything I try to do to build this house. But my final thing, sir, I refer you to the engineer's report that the opponents hired. It's in your package to look at the grade. They agreed to the letter and in totality to the number and the letter of the pad. And I'll just read one statement. In order to drain the property.
Before you do that, Mr. Islar, what page is that in the record?
Sir, I just know it's from Isaacson and Arfman. It's the civil engineer consultant hired. I apologize for not having the page, but it's in that big 135 page packet, AC 20-7. It says, in order to drain the property properly, the property needs to be elevated. The property to your west has to be at a higher elevation. So all I'm saying, sir, as I conclude in 30 seconds, I know you have to go.
Take your time.
I'm in the middle. If I lower the pad, the Mr. Engineer will never give me a grading and drainage plan if I repeat the process. So, because it won't drain, and I'm not the expert. Again, Mr. Biazar and the others are. I'm only submitting to you, Mr. Chavez. I did everything I was supposed to do, and I was given a permit. But that permit is unusable now because of things out of my control. If the house is built the way it's built, it would still be safe for everyone. I'm not disputing that a step wasn't taken. And again, I did not skip it. I wasn't told to take it. And maybe this can be clarified for the next opponent, better rules and clear and rewrite the IDO, whatever. I'm nobody. I'm not legal. I'm not engineer. I just know here's a permit, but wait, we're taking it back. And you have to redo it again. It'll cost you tens of thousands of dollars in 6 months to go. I just ask you to consider that, Mr. Chavez. I had no role. I don't dispute your dilemma, but the real world impact is that this house will be safe. For those that are concerned, the people next door, this house will be safe for you. And once you cut out the driveway and you finish grade, you know that from building before that the front drops. When you cut out for the driveway, you put your xeriscape in, so the lot in the front half drops even more. But to penalize me, sir, for something I had no dealing with and start all over again, I offer that to you. I thank the city and I thank Mr. Chavez.
Thank you, Mr. Islar. I understand where you're coming from on all these issues. I mean, certainly there's one way that this can be dealt with, and that's to work out a deal with the appellants, certainly before I write my recommendation to the city council. My recommendation is in 15 days from today. So is there anything more? Mr. Campbell, is there anything more here?
No, sir.
Okay, let's go off the record. Mr. Islar, I don't have your email address. May I have your email address?
Sure, and may I ask a question when I give it to you? Islar1, my last name. Mr.
Chavez, you want to be off the record?
Let's get off the record.
Okay.
Yes.
All right. Just want to make sure.
But we are on the YouTube. Let's do this. Can you give, Mr. Islar, can you give your email address to Mr. Brito, and Mr. Brito can forward it to the city council, and then the city council can forward it to me, so that your email address isn't made public on the YouTube channel. Okay?
Mr. Chavez?
Yes.
So my letter that responded to the planning director has a CC on it that sets forth Mr. Islar's email address.
So it is public then. Okay.
And
Yeah.
am I allowed to say anything?
We're off the
No.
record, right?
No, we're off the record.
Okay, that would be fine.
Okay.
just
Ms.
would like to
Levinson,
Yeah, okay,
you really don't have an
Thank you.
opportunity to speak here right now
All
at
right.
this time.
all right.
Let's go back on the record for a moment, Rebecca.
Okay.
Okay, Mr. Campbell, what did you want to say?
Nothing. I was just pointing out where the email could be found.
Okay, thank you. Let's go off the record then. Thank you, folks. I will have a recommendation within 15 days. And certainly I would encourage the parties, you're not required to, but if the parties can work something out, then I don't have to write my recommendation to the city can be withdrawn by the city council or whatever. But I think you know where I'm going with this. I think I have a very good understanding of the record. So, okay. Thank you, folks. We're off the record. Bye-bye.
Bye.
Thank you.
Thank you, Mr. Chavez.
Yeah, thank you, Stephen Chavez. This is good.